RVG and another, 2003. The defendants were aged 11 and 12 years old at the time of the offense. They went camping against their parents' permission and set fire to newspapers at the back of a shop. Prior to leaving the scene, they threw the newspapers underneath a wheelie bin and the fire spread to the shop and the surrounding buildings, causing £1 million worth of damage. It was accepted at trial that the defendants did not appreciate the risks of the fire spreading, and did not intend to burn down the building, but the risk would have been obvious to a reasonable person. The jury was directed under the objective test contained in Caldwell that failure to give thought to an obvious risk was sufficient mens rea for the offense, and the jury convicted the defendants. The question raised by the CA in RVG was whether a defendant could be properly convicted under CDA 1971 S1 on the basis that he was reckless as to whether property was damaged when no thought was given to the risk, and they did not think about the risk due to age or personal characteristics. The CA upheld the conviction. However, the House of Lords overruled the decision and brought about the demise of the objective test of recklessness found in Caldwell. Lord Bingham stated that the rules in Caldwell led to obvious unfairness, especially when the defendant's capacity to appreciate risk is inferior to others. The HL, whilst not overruling the decision in Caldwell, sought to reinstate the law as it was thought to be interpreted before 1982 in line with the Cunningham test, whereby a person will be reckless only if he or she foresees a risk and nonetheless goes on to take the risk unreasonably. The test for recklessness used by the HL reverts back to the draft criminal code, which has a number of differences from the subjective test originally used by Cunningham. Firstly, Cunningham only refers to the taking of risks as to the results and does not mention the circumstance. In addition, the draft code adds an additional restriction where the defendant's risk-taking must have been unreasonable. In summary, balance the seriousness of the risk against the gravity of the harm. The law following RVG. Following the case of RVG, the court have applied the definition of recklessness to several cases in relation to voluntary intoxication, where the defendant's foresight of the risk at the time of intoxication is not investigated. What the court is concerned with is whether the defendant, if sober, would have noticed the risk at the time of acting. In the case of Booth v. CPS, the court upheld a conviction for criminal damage when the defendant was drunk and stepped out of the way of a car, causing a collision and £517 worth of damage. It was ruled that despite the defendant being drunk, he must have closed his mind to the risk. Despite the rules laid down in RVG, the application in this case appears to be objective in regards to foresight. There are still issues that arise from the application of recklessness within the criminal law. If the approach to recklessness is too subjective, guilty parties can easily avoid liability. However, if the test is too objective, it can also lead to injustice. The HL decision in RVG has prompted the question, why was the Caldwell rule not modified instead of merely being departed from? Lord Bingham addressed this by saying that if the rules were modified for children, it would also need to be modified for defendants with mental disabilities, which would cause problems for a jury. This did, however, indicate the kind of modification that was needed, in that a defendant should only be regarded as acting recklessly where the risk would have been obvious to them, and they had given thought to it. It is suggested that a combination of both subjective and objective approaches be adopted in order to address this issue.